Assalamualaikum and very good morning to Miss SITI, Nur FATHANAH and my fellow classmates. We are from Group 7 and today we're going to present about the provisions for female employees as stipulated in the Employment Act 1955. My name is Nurul Nisa binti Jamaludin and my fellow group members are consisting of Nur Anis Suraya binti Nur Azalmi, Nur Farrah binti Mohd Hasnal, Ainaa Najwa binti Zamri, and Sharifah Najiha binti Syed Ahmad Azalmi. So, the provisions for female employees as stipulated in the Employment Act 1955. So, as been acknowledged, women have been contributed significantly to all aspects of Malaysia's development, particularly in cultural, social, economic, and even political aspects. As of now, Malaysian women has played a pivotal role in the labour force, be it in the professional or non-professional sectors. However, some women in Malaysia still have to face institutional and social limitations as they fought for the equal rights and opportunities in the employment market. So basically, women in Malaysia generally do well in the academic qualification, but however, some of them might slip down the opportunity to be working, as mainly to the reason of having to considering the family commitment and some other prejudicial harassment in the workplace. We know that ever since our independence in 1957, the right of Malaysia's women as citizens to engage in political and administrative growth of the country have been acknowledged by the Federal Constitution and are secured by it. In the Federal Constitution itself, it has outlined that everyone are equal in the law and entitled for the same rights and protection as provided in it. This include that there shall be non-discrimination. There shall be no discrimination to anyone regardless their social background in order to acquire the same right in every aspect, including the employment, which also apply to both genders. While in the topic of women employment in Malaysia, the Employment Act 1955 is the act that governs every employment matter, which also encompass the provision that protect women in the workforce. So basically, the Employment Act 1955 covers both unionized and non-unionized labor and employers. But then it only applies in Peninsular Malaysia and not Sabah and Sarawak, because Sabah and Sarawak has their own labor ordinance that apply in both states. So basically, the Employment Act 1955 is the legal framework that governs all employment practice. This include the aspect that equally apply to both genders, such as the service contract, the wages, the working hours, the holidays, the annual leave, sick leave, termination and layoff benefits, and many other benefits. Okay, so as of currently, in the Employment Act 1955, there are 4 provisions that provided in it that is used to protect the women employees in the labour force. So the 4 provisions are known as, the first one is the maternity benefit, which covers the maternity leave, the allowance, and the restriction from dismissal and termination. The second protection is the prohibition from night work. This to protect the woman from any harassment, be it in any type of harassment. The third provision is the prohibition from working underground, such as working in the tunnel or the mining sector. And lastly is the exemption to the prohibition by the Director General of Labour and by the Minister as well. So, all of these 4 provisions will be discussed in depth by my fellow group members.
Assalamualaikum warahmatullahi wabarakatuh. My name is Nur Farrah binti Mohd Hasnal, and today I'm going to present about the first provision, which is maternity benefits. The first maternity benefit is maternity leave. Maternity is the period of after woman give birth to her child, according to Section 37, subsection 1, sub A Maternity benefits refer to a period of not less than 60 consecutive days whereby a female worker abstains from work in the issue of children or child resulting after at least 28 weeks of pregnancies. There are three benefits in Malaysia, maternity benefits in Malaysia. The first one is not less than 60 consecutive days in respect of each confinement. Under Section 37, Subsection 1 Sub A of Employment Act, female employees shall be obliged to maternity leave for a time of not less than 60 days consecutively in respect within each confinement and shall be obliged to a maternity allowance and in consideration of the eligible period. Secondly, can commence maternity leave at any time during the period of 30 days where female employees can start their maternity leave before the 30 days prior her confinement. Such abstention is not considered as maternity leave and is not eligible to any maternity allowance in consideration of the days on which she refrains from working for a total of more than 30 days prior her confinement. And lastly is commence maternity leave during 14 days preceding confinement. According to Section 37, Subsection 1 Sub B, under Employment Act elucidate that when a female employee is permitted to maternity leave, she must therefore not begin sooner than 30 days from the date of confinement. If she inefficacious to conduct her task competently, the employer can, however, recommend that the female employee take such 14 days leave earlier. The second maternity benefit is maternity allowance. Maternity allowance is the amount of salary received by female employee for each day of their maternity leave at their regular pay or at the rate specified by the Minister of Human Resources, whichever is higher. A female employee shall be sanctioned to a maternity leave allowance from its employer for an eligible duration if she has been working for the employer for a period of accumulate of not less than 90 days in the 9 months prior before her confinement, and she has been working for the employer 4 months prior her confinement. The first is rate of maternity allowance. According to Section 37, Subsection 2 Sub B under Employment Act, the female employee shall be paid by the employer every day during her maternity allowance at her regular rate of pay for 1 day. Apart from that, if the female employee is working at a monthly rate of pay, she shall be assumed to have obtained her maternity allowance if she keeps on sustaining her monthly income after her abstention from duty during the qualifying period without subsiding in the value of her abstention. According to Section 40 of Employment Act, it is stated that where a female employee is only entitled to claim the maternity allowance for one employer only. Secondly is payment of maternity allowance. According to Section 38 of Employment Act, the payment of the maternity allowance is the same as the payment wages, and it must be paid not more than the 7th day after the last day of that wage period. Under Section 41 of Employment Act elucidate that the employer shall pay the maternity allowance to the nominee nominated by the female employee even though she is dead during the confinement, for which there is no such person, her legal representative, and allowance at the rate determined or specified by subsection 37 subsection 2 from the date of commencement of her maternity leave to the day prior preceding her death. Thirdly is suspension or loss of maternity allowance. There are two causes to the loss of maternity allowance. Firstly, maternity allowance can be suspended if a female employee who is about to leave her position that is going to be constricted in the period of 4 months failed to inform her employer about her pregnancy causes her not qualified to receive any maternity allowance from the employer. Secondly is a female employee must inform her employee in the period of 60 days before the expected confinement. She needs to notify her employer about the date she expected to commence her maternity leave. If she fails to do so, her allowance can be suspended until further notice. The last maternity benefit is restriction on dismissal and termination. According to Section 42 of the Employment Act, restriction on dismissal and termination happen when the female employee stays absent from her job after the end of the qualified period as a result of illness approved by a licensed medical practitioner arising from her pregnancy and confinement which making her debilitated for her job. She shall be shielded from dismissal for a term of up to 90 days following the expiry of her maternity leave. It shall be an offence if her employer dismisses her from her job or position during those periods.
Hi, Assalamualaikum warahmatullahi wabarakatuh. My name is Sharifah Najiha and I'm going to present the second provision, which is prohibition from night work. The second provision is prohibition of female workers from working at night. Section 34 of the Employment Act 1955 specifies that the prohibition of night work for women in Malaysia means that no employer can allow any female worker to work in any industrial or agricultural duty between 10 a.m. and 5 a.m. or to work on the day without providing a duration of 11 consecutive breaks. From my point of view, government of Malaysia does not allow any female worker to work at night. It is because they are for their own safety. Since most of bad things happen during the night, such as crime cases like driving under the influence of alcohol or drugs, assassination, sexual assault or rape, and also robbery. Daily working at night can cause multiple health problems like tiredness, poor sleep quality, depressed mood, and indirectly cause relationship of family problems too. However, the effects may vary from one individual to another. However, there are still exceptions that was given by the Minister of Labour for females to work at night. For example, doctors including medical officers, clinical specialists, as well as medical consultants that needs to be in hospital for on-call. They need to ensure optimal care for newly admitted patients. Other than that, the doctors are responsible for maintaining the same standard of care after hours for patients treated. On-call means that the doctors have to continue working after their working hour. The doctors need to be ready for emergency, accidents, surgery, and others during on-call. Regardless, resting rooms were provided for the doctor to take naps. There are some countries that allow their female workers to work at night, and one of them is France. The French Parliament adopted in November 2000 a bill abolishing the ban on women's night work and imposing laws on the work of women and men at night. In France, in every form of business, the legal period of the working week is 35 hours, and also the workers cannot work more than 10 hours a day. Night working in France cannot be over 8 hours a day and 40 hours a week between 9 p.m. and 6 a.m. in principle. Workers also will earn weekly rest days or additional night work pay. Legislation introduced in 1979 lightened this prohibition by adding a special exception for women in management or professional manager roles, while the 1987 legislation allowed a new system of exception for which the use of night work of women is justified on particular grounds or in the event of successive changes. All employees need to be given breaks at least for every 6 hours, minimum of 20 minutes for each break.
Assalamualaikum warahmatullahi wabarakatuh. My name is Ainaa Najwa. So I would like to continue the presentation about the third provision on female employees in Malaysia, which is the prohibition from underground work. So basically, underground work is known as a work in tunnels or other lagging work with pipes, whilst earth reinforcement and so on. So basically, according to the Department of Safety and Health in Malaysia, underground work is one of the classification of work in the category of dragging work. All work on the underground can be considered as high-risk construction work. The prohibition from underground work for the female employees also has stated under the Section 35 of Employment Act 1955. So basically in Malaysia, women are not allowed to work underground unless they are instructed by their Director General of Labour. From my point of view is, the government in Malaysia has places a great emphasis on health and safety of workers, especially for the female employees. Therefore, women are not allowed to do all the underground work. This is because maybe there are some safety and health risks that must be faced for the employee when they do the underground work. However, there are some countries that allow female employees to do the underground work, and one of the country is India. So basically, for example, in this case, the Ministry of Labour in India give exemption to women or female employees to working in underground from the provision of Section 46 of the Mining Act 1952. Previously, the present rules in India also do not allow the women or the female employees to do the underground work. But after that, the Ministry of Labour in India has decided to amend the rules due to some reason. Even the Ministry of Labour has decided to amend the rules, but the Ministry of Labour also has remains the several condition in a new rule for women or for the female employee who do the working in the underground, such as the owner of a mine only can be deployed the woman or the female employee between 6 a.m. until 7 p.m. and not more than that. Other than that, the woman who had deployed shall be provided with any adequate facilities and safeguards regarding the occupational safety, security and health. In this case also, the ministry also has decided to amend the rules where at least they must have 3 workers or the 3 female employees should be working together in the underground at the same time.
Assalamualaikum warahmatullahi wabarakatuh. My name is Nur Anis Suraya binti Nur Azmi, and today I will explain about the fourth provision, which is exemption to the prohibition. In general, exemption is defined as a fact of not having to obey a rule or do something that other people have to do. Therefore, in this context, exemption to the prohibition means that a female employee can get an exemption from following the prohibition stated in the Employment Act 1955. There are 2 types of exemption, which are exemptions by the Director General of Labour, or also known as DGL, and the second one is exemption by the Minister. The first type of an exemption is the exclusion by the DGL. DGL is a person who is appointed under the Section 3, Subsection 1 of the Employment Act 1955. There are many functions of the DGL, and one of them is to give an exclusion to certain prohibition for some people. As for the example, there are some works that women are restricted from doing, such as they are restricted from doing underground work and also to work at night. However, they are free to do the works if the DGL allows it. The second type of an exemption is the exemption by the Minister. This Minister is referred to the Minister of Human Resources. As stated in Section 36 of the Employment Act 1955, the Minister of Human Resources have the power whether to allow or prohibit the employment of female employees under certain conditions or circumstances. That's all from me. Thank you.
So, as of the conclusions, I can conclude that it is very crucial to have these provisions implemented by the government in order to guard and protect the female employees from harassment at the workplace, as well as to lessen the possibilities of women workers in facing the discrimination and prejudicial statement at the workplace, at the labor practice. So, by having this provision being implemented, Women employees are now being less discriminated and prejudiced at the workplace. So the women are now free to enjoy the just and fair principles in their employment as enjoyed by the men. So in the term of maternity benefits, the provision itself is a must because we need to remember that working women is not only their job is not only to work, but they are also the one who carrying the baby, they are the one who giving birth, and they also have the responsibility toward the family commitments. So we must acknowledge them by giving this kind of benefits for them because they are very entitled for it. They are very, very entitled for it. And although we have this provision in Malaysia, but then it is still being debated by certain group of people as they sought to amend this provision to become better as in the term of the period of the maternity leave and more of it because if we were to compare our country with another country, we are still left behind. Next, regarding on the prohibition for night work and working underground. So these two provisions is very essential, are very much essential, as well as the maternity benefit, because these two provision is to ensure that the harassment towards the women employees will not cause any sin at the workplace. And this provision also view thoroughly all the possibilities to secure the safetiness of the women employees at the workplace. So on the other hand, although the act prohibited as such, but then it also let out the exemption by the Director General of Labour and Minister as well, where both of them have the power to negotiate the prohibition to allow the woman to work at night, to work underground when the women employees themselves wants or have to work at night or underground. So that is all for our presentation on the topic of the provisions for female employees as stipulated in the Employment Act 1955. So thank you for listening.